bless each of you. Welcome to the Dwelling Place. This is Evangelist Doris J. Roberson, and I want to greet you in the name of our Lord and Savior Jesus Christ. We thank and praise the Lord for another opportunity to come and share with you on tonight. Many of you were inquiring back in March about our last presenter, and tonight I am so thankful to have with us attorney Gwendolyn Cook Jones. And we are excited about the information that she's going to be sharing with us. Tonight, we're talking about answering the questions to estate planning and wills. Attorney Jones comes to us as a native of Michigan, out of the city of Detroit. And I thank God that she's licensed here in southeast portion of the state of Michigan. And she has an extensive, impressive bio. And I'm just going to highlight a few things that stood out to me. The one thing that stood out to me, first of all, is she loves God and she serves God passionately. And in serving God passionately, she believes this is her passion to give back to her community. How can I make a difference in my community? What a blessing. And in so over her 25 plus years, she's been doing that in many different ways. She's a part of the women society, those that are practicing law, and she'll correct me if I have that wrong, but we're thankful that she volunteers her time to provide to the Christian women legal services. And the other thing that is a blessing, she mentor graduate students that are going into law. And so what a blessing to be a woman of God that loves God, serves her community, and believe and being a blessing to others. She also is certified or has a certification as a diversity, inclusion, equity, inclusion certification. That means she's all inclusive in terms of serving all mankind, regardless of what nationality. She's an advocate, and she advocates for enhancing and advancing voting rights. So this woman of God is active in her community, and I want you tonight, take time to invite someone and encourage them to listen to this woman of God, as well as the information that she has to share. Before I turn it over to her, I'm going to offer a word of prayer, and I want to encourage you, if you have questions tonight, she's going to present her information, but if you have a question, I want you to put it in the chat. And I also want you to make comments, and sometime in making comments and reinforcing that information and writing it and noting it, it retains you. You're better off at retaining that information. So let us go to the throne of grace. Father, we thank you once again for the opportunity to be a blessing to the people of God. We asked, oh God, that you would continue to bless this ministry as it ministers into the lives of people all across this country. We ask that you would bless our presenter. We ask, oh God, that you would give her what, oh God, that you would have us to receive as we enhance our knowledge regarding estate planning and wills and all of the things associated with preparing for the end of life. And we thank you, Lord, that you are the center of attention on tonight. And we invite you, Lord, to bless us and help us and strengthen us in these blessings. We ask in the name of our Lord and Savior Jesus Christ, and bind every attack of the enemy that comes to deceive, comes to try to distract us. We bind it and cast it out. In Jesus' name we do pray. We thank you once again for joining, and we're going to ask our guest now to take it from here. I'm going to remove myself from the screen. I'm going to give it over to her. And I know those that are on YouTube as well as on Facebook, feel free to ask questions, put it in the chat. Let us know that you're there. Let us know that you appreciate the information. And so at this time, won't you welcome our guest, attorney Gwendolyn Cook Jones. God bless you and thank you for joining us on the Dwelling Place.
Well, good evening, everyone, and thank you, Evangelist Robinson, for that great introduction. The Bible tells us that a good man or woman leaves an inheritance to their children's children. That's in Proverbs 13:22. So as we go through today, I hope that I say something that will help you, those of you that have a estate plan and others that are planning to get one or thinking about it. I hope something encourages you to start making steps towards that way. I'm going to go through a couple of slides, and forgive me if I'm a little bit academic. I did not tell Evangelist Robinson I also teach class business law, so I kind of can get on the side of being more academic sometimes, but I'm going to try to speak to you in layman's terms and not use a whole lot of legalese as I do with my clients, so that you can get the understand the information and digest it and hopefully process it in terms of making some steps toward planning your estate. Let's see. Let's go on. Okay, so today we'll talk about estate planning. I'll define it, and we'll go over some of the estate planning documents, and we'll talk about the benefits of having one, and we'll have time for some Q&A, some questions. So what is an estate plan? An estate plan is a process that we use to set up how our assets and property will be distributed upon our death, and how our assets and properties would be managed if we become disabled or incapacitated, and also who would make life or death decisions on our behalf if we're not able to. So we talk about when we die, and also the estate plans includes documents that would be useful for our life while we're still here. So estate planning documents, these are the ones I usually recommend for my clients, that you consider getting a will, a durable power of attorney. I'll talk about each of these. A power of attorney for healthcare, and a trust. So this is a question I was going to ask before I give the answers. Why do you think people don't have estate plans? And Evangelist Robinson, I'm not sure if the audience is able to speak back with me, interactive. If you are, you can put some things in the chat box if you think of some reasons why people don't have estate planning, or maybe yourself why you haven't put one in place yet. Let's see. Okay, 5 reasons why people don't have an estate plan. We know that it's helpful to know why this is happening, not just that it is happening. And to that end, here are some of the reasons that people come up with. And I've been in one of these categories at one time. And so have my parents and my sisters, my siblings as well, that we've not made the time. We may have heard the information, but we just haven't made the time, or we think we have too few assets. Or, a younger person may think they're not old enough. That's for, when I'm much older. And another reason might be I don't really know where to start. And lastly, you may think, well, it just costs too much, to get a will. I just went over the documents, a will, a power of attorney for healthcare, a trust. All those documents kind of sound very costly.
Excuse me, Attorney.
I'm sorry.
Attorney Gwen, for some reason, the PowerPoint is not moving, or it's there, but it is not following the slide. So.
Okay, let's see. Okay, let me start back. Okay. All right. Are you able to see that one, the first one?
Okay. No, it just shows like it's the that the slide is like you just open it up and.
Okay, we're sharing the screen. Let's see. I can, excuse me a moment. Let's see if okay, it says I'm sharing. Let's see. share with this document and see who it's shared with.
I'm sorry. You know what?
Mhm.
I don't want to take away from your presentation.
Oh, that's
And
okay. Let's see. It is important that. Okay. Are you seeing what I'm seeing right now?
what I'm seeing is just a blank white sheet. And it didn't have the so from your maybe let's see, I'm it could be, and I don't know if that is in the settings where
I have no idea where I am now.
you know what I should what you can continue, and I'll just remove the blank sheet and you can still talk from your PowerPoint. Um, and it's I apologize for the technical difficulty because we had a plan in place and that
What
plan
about? Okay, I see. All right then.
because it's still nothing is nothing is let me see if I hit present and if that's going to change. It's usually it's not like that. um let's see.
Okay, let's see here.
Video file,
See if I go to present.
share screen. No, that's not it.
Okay, attach a copy instead. Okay, it's telling me I can do a couple things here. Let's see. Present. Hmm,
Screen share was canceled. Make sure you click share. That's um,
hmm. Okay, let's see if if I stop sharing. Let's see and start over. All right, there we are. Let's see. You don't see any of this. Okay.
no. I think the
It says
for
please
did you create
upload.
it in Google Slides or
It says to let's see. Please upload your presentation to share it. We'll update the file format. Attach a copy. All right, it's okay. So I'm attaching a copy of the PowerPoint. It gives me an option to attach it.
okay.
So I'll attach a copy. So are you able to see if a copy is attached?
Did you download it?
They gave me an option to attach it or to download it. Let's see.
I think
Okay.
when in
Attach a
before
copy instead. Okay, and then a PDF. Let's see. Where's the PowerPoint though? Okay, it's giving me two options, either PowerPoint presentation or a PDF. So it is a PowerPoint.
right.
Okay, sign in.
Bear with us, audience. We certainly appreciate your patience.
But this is all on the StreamYard. Okay. All right. Maybe if I could send a copy to you on an email, would that help?
Um,
But it probably needs to be in the StreamYard. Uploading, recording, staying student. Okay. Okay. It said attach to download. So where can I see where downloads are on this StreamYard?
oh gosh, I my
Oh, I see.
apologies.
Yeah. We need your husband.
Oh my goodness. Let me see. I don't want to do it on live. we could, let me see.
Maybe I could just send a copy to you, and then I'll just talk as you bring it up on your share your screen.
Okay, let's see if that works. Just tell me when.
Okay, let me close out of here. Let me close out. Make sure I have the right one. So I had two versions. Let's see.
So a couple of people said just go ahead and talk it through, and we could. And so what I can do, if you want, no, I don't.
Okay,
Did
for
you?
sake of time, maybe.
Yeah, because of course the information is critical and is important. And we just ask the audience to take notes. Um, those that will inbox me, if you want, we can send them a PDF.
Okay, let's do that, because I can definitely share it with your audience. Okay, all right. I do apologize,
So
everyone. I do apologize.
it's my apology. It's not when it it was my schedule, definitely. So it is not on Attorney Gwendolyn. It is a situation that occurred prior to her coming on. So I do want to let everyone know that it is definitely not on her end. We had it all set up. It's just that it didn't happen. So please forgive us.
Yeah,
Thank you for
yeah,
your
please forgive us.
patience.
We did do a check yesterday, and we were trying
Yes,
to prepare as best we can. And some things
yes,
happen. So, we're just
things
saying that
happen.
this is, it's valuable information, and sometimes the enemy doesn't want you to get this valuable information. So I'm going to take it from that standpoint, and
Exactly.
we're going to talk about it anyway. And please ask any questions. Let me know if I'm going too fast, since I'm the only one looking at the slide.
Yes, yes, yes. No,
Yeah,
no. If you want to go back to when
okay,
you were starting to talk about
okay, I could go a little slower.
establishing, yes.
Okay, all right, let's go.
Right after you had asked the question to the audience, and do you want me to restate, remain on, or I can remove and let you have the whole screen?
Yeah, I guess you can remove and let me have the whole screen, as long as it doesn't
Sure.
matter. You can stay on it. It doesn't matter. Yeah.
I'm going to remove.
Okay. Okay, great. We were, let's see where we were. We were talking about in-estate plan and the documents. One of the documents is a will, and one is a durable power of attorney, and one is a power of attorney for healthcare, and the other documents would be trust, various types of trust. So I asked the question, what are some of the reasons why people don't have estate plans? And I said before, I've probably been one of these categories, or certainly my family has been in one of these categories. But one is that we haven't made time, and others that we kind of think we don't have enough assets, and maybe we're not old enough to do this. It's something older people do, maybe retirees do, or we just don't know where to start. Or we think it really costs too much. This is what the rich people do. We don't have the resources to have a will and to get those things in order. But the truth is that everyone can benefit from ensuring that their assets and finances are properly taken care of during their life and after their death. I did have a kind of a cartoon here you can't see, but I would describe what I'm looking at. It is an older man on a walker, and his son is standing near him, and they're looking at a garage full of stuff. It's old file cabinets, lamps, all the things that you would put in your garage, if you live in southern states, or maybe the basement if you live in some of the northern states. And the older gentleman says to the son, which is, he looks like he's probably in his midlife, he says, one day, son, all of this would be yours. And that's what all of us, we gather things that were very important to us at different times in our lives. And we, I certainly have things I probably need to throw away, but this got sentimental value. And so our parents have as well, and we will have for our children as well too. But if we don't really make a will out and set describing what items we think are valuable and which ones we want to leave to someone. When this particular son comes after the father's death, this is all going to look like junk to him, which, it looks like just at first glance. And we don't want that to happen. If we, some of the things we work for a long time and they're just valuable, and maybe some family heirlooms that we really want to pass on. So a will helps us get those things in order. And so that it wouldn't be difficult for our children. They wouldn't have to go through this. They got their lives as well, and not to make it burdensome on them. All right, so a last will and testament. This would be dying with the will, and some of the legal term would be dying testacy. So you've taken the time to write down exactly what you want to happen. You dictate who would receive your real property, your personal property, which would be your savings account, your banks, stocks and bonds, any significant, valuable jewelry that you have, or anything of value to you. You write that down in your will, and the person's your personal representative, whoever you name in that particular document, someone that you trust, and usually it is your children. Let me back up for a moment. If it's a husband and wife, it's usually the husband names the wife as the executor, and the wife names the husband as the executor, and then they name an alternate, and usually it's one of the adult children. It could be first alternate and second alternate, maybe the first child and then the second child, or we know our children. We know which ones might be better with taking care of this part of the business, and which ones may be better taking care of other things for us. But those documents have to be dated and signed and witnessed by two adults that are not receiving under the will. I will say right here that a will does not avoid probate. However, it does shorten the probate process significantly. Okay, so I do mention that we have to have the mental capacity to sign a will, to make a will and to sign a will. We have to be of sound body and mind. And the mental capacity for a will is a little less than that you would need if you were signing a contract. You just have to have sufficient legal capacity that you understand that you're disposing of your property. You understand the nature and extent of your property. I have a house here, I have a house in Florida, that what you're doing is that you're giving it to particular people. You want them to have it. And you understand that when you sign this document, the effect of it, that it is your last will and testament. I say that because a person can put a will together if they're on so-called their deathbed, as long as they have the mental capacity sufficient for a will to dispose of their property over the 3 or 4 things that I just mentioned. But they would not have the mental capacity to enter into a contract, arm's length agreement with someone else. But so a will could be drafted at different times. It's certainly better if you do these things early, but there has been, you've seen it on the movies probably, with someone signing a will on a deathbed. So it is possible and it is legal. Let's see here. The second thing I kind of put in here is that it's another cartoon, like a lady's going to the attorney and she's asking them, she wants to change the will, and the attorney is saying that I'm afraid it's too late to change it now. And so once things are in place and the person has expired, there's nothing we can do about it. So if you have a will, and some of you probably do, or if you're thinking about putting one together, and maybe you put one together and then you want to make some changes, you want to do that as soon as possible, and while you are have the capacity to do that, because once things are set in stone, they're just, it's pretty much set in stone, becomes effective immediately after the person passes away. So I want to talk a little bit about a power of attorney. I mentioned 2 initially. There's a power of attorney, a doable power of attorney, and a power of attorney for healthcare. And you may hear those terms just plainly stated as a power of attorney. And the reason the ones that I put together are called durable power of attorney, because they survive even if you become incapacitated. So a power of attorney, I usually explain it that these are good documents just to have in place, even if you don't have any reason to put one together necessarily. These are good things to have in place now. And so I said, think of if you, you slipped and fell and you just sprained your ankle and you're not able to get out and do your business, or, as you get older, some people have knee replacement surgery, hip, all those sort of things. These are not life threatening surgeries, but they do incapacitate you physically in terms of getting out, doing the types of taking care of the business that you probably need to take care of. So a doable power of attorney, you would name a person, would be your agent. It's called attorney in fact. It's got to be someone that you trust. And as I mentioned before, usually it's the husband or the wife or an adult child that you feel would manage your finances in a prudent way that and that they can be trusted in such a way that you would be managing your affairs yourself. And so initially with the power of attorney, you're directing what the person to do. Take this document, go to the bank, do X, Y, and Z. Go to the bank or my brokerage, and speak to so-and-so and bring the document with you. Or you can make sure those places have this document on file. And so the term doable is saying that once I become incapacitated, that I can't maybe make those decisions, the person already has authority to do that for me is why I'm living. And so the difference between a power of attorney and the will, one big distinction is that, because I've had clients come to me and they say, my husband passed away, but I have power of attorney over them. And I have to say the power of attorney no longer has authority when the person dies. It's only while someone's alive that you're able to stand in their stead, so to speak, and take care of the business the way they would want it to be taken care of. But once the person passes away, then the will becomes the legal document that we have authority for to carry out a person's wishes. The other document is the power of attorney for healthcare. You may hear the term power of attorney for healthcare, or you may have heard the term living will. But it directs what happens to us at the end of life if we are have an illness that suggests or the doctors recommend that we be on some type of life support mechanism or instrument to keep us alive. We direct whether or not we want that to happen. And maybe we do, but we just want it to happen for a certain period of time. The doctors are saying there's nothing they can do. We're going to be in a vegetative state. Then we don't want to stay in that state very long. But the document says basically that you want the doctors to do everything that they possibly can to sustain life. But if it gets to a point that you are directing that this person make a decision, an end of life decision for you. Okay. All right. I asked the question in terms of a will breakdown by race. What do you think in terms of white, Black, and Hispanic? And what are the percentages? And this is really surprising for me because had I not did the research, I would have thought that in terms of a white person, that their percentage would be a lot higher than that of a Black person or Hispanic. But the numbers are coming out like this. There's 35% of white people that have their wills prepared, and there's 29% of Black people, African Americans, that have their wills prepared, and 27% of Hispanics. So what this data tells me is about a third of the population, the breakdown by these particular majority races that have their wills. So in terms of preparing a will, the general population, on a third of it, really have taken time to consider preparing a will. But some other interesting facts is that 41% of the people between the ages of 18 and 34 have a will, and 34% of the people 35 and 54, not have a will, have discussed estate planning with someone. 52% of the people don't know where their parents store estate planning documents. And after today, that number will definitely decrease for us here, because once we put this together, it's certain that our family know where we're storing these documents. And let's see, 60% of people without a will reported not taking any action to create a will, and also haven't made a living trust or any other estate planning documents. However, this is interesting. 77% of pet owners designate a guardian for their furry friend. It's interesting. So people have taken more interest in their pets than in their own estates, or making provisions for their children. Okay, the next question was, or that information statistics that I gathered was, what's the most common age to have a will? The categories were 18 to 34, 35 to 54, 55 to 71, or 72 and beyond. But you think about it for a second. The most common age to have a will is the last category, 72 and beyond. It is 81%, the overwhelming majority of people consider getting their will done once they reach the age of 70. 45% between the 55 and 71, 27, 35 to 54, and 24%, which stands to reason the younger, 18 to 34, which category don't usually think about the end of life considerations at that time. They do tell us that since the COVID, more people are considering getting an estate plan or even been considering at least getting a will done. That was some other interesting. That's okay. All right, what happens if someone dies without a will? I talked about the benefits of having one and the need to have one. So we call that in legal terms that you die intestate. And dying intestate refers to an individual dying without a will or estate plan. That means that the state, wherever state you're in, I'm here in Michigan, whatever state you're in, the state controls the distribution of your estate. And they will follow that state's intestacy laws. Here in Michigan, we will follow the Michigan laws of intestacy. And I just give an example without going over all the laws, what would happen. But if a person is married with children or grandchildren and a living spouse and they die without a will, the spouse will receive the first $150,000 of the estate, and the spouse will receive half of the rest. So if you have a $300,000 estate, the spouse will receive half of that, $150,000. The other $150,000, the spouse will receive half of that, $75,000, and the children will split the other $75,000. This is interesting for a number of reasons. Just say if you have a blended family and the husband passes away, and maybe the couple didn't have any children together, and the children that are part of the marriage are only the husband's prior children. So he passes away, and his spouse receives $150,000 and half of the other $150,000. So the spouse receives 150 plus 75, and his children only receive 75,000. That may not be the way he would have wished things to be distributed. But without a will, the default would be that the state would have to be divided according to the intestacy laws of that state. I had another kind of little cartoon here that says there's nothing left. He made sure all his accounts were hacked. And I put that here because sometimes when, especially if a person dies without a will, intestacy, the family is thinking it's something and there really isn't anything really. And I had a case where the gentleman died without a will, and this was a second marriage for him. They didn't have any kids together, and his kids were adults by the time he and this particular person married. And so the house that they had together, it was joint, so the wife was definitely getting the personal property and any joint bank accounts that they had together. But the children, there was some bank accounts that we weren't quite sure, just in his name. His adult child, I remember taking him to the bank. I remember Dad had this account, I think it was PNC Bank. And so we went through all the open state in order to get permission to authority to have the bank release the information regarding this account. And we find out that it was nothing, and I mean nothing. I think it was like $1. So a lot to do about nothing, so to speak. So it's good to have things in order so that your kids know. They don't necessarily know the value of what you have in your account, but they need to know that these particular accounts exist and where to find the information on them. Since we mentioned bank accounts, and I did mention wills, I did not mention what things probably would not have to go through the probate process. So I'm going to just talk a little bit about the probate process, and I'm talking about it from a vantage point of Michigan here, but most probate processes are generally the same across the nation. They may have little things that are, particularities with respect to state law, but for the general purposes here, I think this is something you can take away from here and probably think about it. It could be and use it going forth in terms of just thinking what a probate process entails. Okay, the probate process deals with validating the will. So you got your will together, a person passes away, they take that will and they take it to the probate court, and an estate is open. So this gives the personal representative then authority to act as prescribed in the will, to pay the funeral costs, to pay off the debts, to distribute the assets to the lawful heirs and beneficiaries. The creditors, the probate process here in Michigan would take about 9 months, at least 4 months, probably 5, because the creditors would have about 4 months to bring any claims toward the estate. So that's about, the whole process would probably take about 8 to 9 months. I have not seen it take any shorter time than that. And then there's the transfer of property. Sometimes there's selling. You have to sell the property, or maybe gather all the real estate and all the personal property. But it gives the person the authority to do that, and really, to me, some assurance, because if there is any disagreement among the siblings, the will just speaks for itself. The parents have taken time, or the husband has taken time, the wife has taken time to write down exactly what they want to happen. And so that alleviates a lot of potential disagreements and bad feelings among the siblings. I've seen it firsthand, and maybe you've seen it firsthand too. But it could really destroy relationships because all the siblings, all of us feel we have just a very, for the most part, close relationship with our families and with our parents in particular. So I've heard that mom will want me to do this, or dad will want me to do that. But if it's written out, no one can really, they can say something, but they can't really change it. And it really helps your children. It's already a very difficult time for them when someone passes away. But to have everything written down, then you're preserving a relationship. You want your children to get along. You want them to, they're going to need each other at some point. So you preserve the relationship among your children or family members by getting the will together, prescribing exactly what you want. So that's the will process. That's the probate process. Kind of a little bit of a nutshell. It validates the will, lawful heirs and beneficiaries, helps you with the creditors, because any creditor that doesn't make a claim against their estate within 4 months here in Michigan, then they lose the ability to do that. And that could be very helpful going forward. Okay, let's go on. Okay, another important issue I want to talk about: why is it important for every Black person to have a will? And the real big reason, and you may have thought about it as well, the lack of estate planning is one of the several factors that lead to the loss of land in the African American community. In the absence of a will, the land becomes vulnerable to partition and sale. And when this happens, families lose property and wealth built by a previous generation. So if we don't have a will, it really affects the generational wealth, for the next generation and the next generation and next generation. And this has happened, I know, in my own family in the South in particular, and extension family, relatives that are not necessarily close relatives, but we've heard about situations where the land has been taken because they were knowledgeable in terms of paying the taxes, or they got swindled out of it, or just, in my opinion, it's just taken supposedly for eminent domain. They decided to do some public project on the land and it was taken. And just not knowing enough about things like this, that we've lost some of the generational wealth that we could have had over the years as a people. And as I said before, we need to get our wills together so it won't be a financial burden to the family. It could leave the family crippled by financial burdens to pay for the burial expenses. And right now, the average cost for a funeral pre-COVID would have been $10,000. Now we're probably up to maybe between the 15 and 17, $20,000 if you're not being cremated for the family. So, and most people just don't have that extra cash lying around. So it can cause an incredible number of headaches and hardship on the family. And the other thing is that when a person dies without a will, it often, as I said before, creates an environment for sibling disagreement, squabbling over assets, and could be followed by years of broken relationships. So having said that, that is important for African Americans to have it. What are some of the reasons you think we don't have it? We have not put a will together. We haven't thought about an estate plan. One of the number one reasons is that we distrust the government. I know that older people don't want the government in their business, and they think about putting a will together. Somehow, that's going to involve the government. And even as I went over this probate process, which is not a long process, but in terms of in someone's mind, that's the government. There's too much involvement for the government. And older people, they distrust sometimes banks and things like that. They've had the money at home, in the mattresses and the walls and things. And I have a case recently, not a case, a friend of mine, her son buys property and rehabs it here in Detroit. And one of the properties that he bought, he found money that was stuff that was in the walls. When he went to tear it down, there was some money there, not a whole lot, but a couple $1,000s that was in the walls. And probably someone had just put that there years ago because that was a way that how we would keep our money and not put it in banks or only put some of it, always keep some, with us. And another reason why African Americans don't have a will, I believe that their children will ultimately inherit the land. Let me read that over again. I believe that their children will ultimately inherit the land. Some people, as with my grandmother, my mother was an only child. This was not how she thought, but some people would think, I only have one child. She's going to get everything anyway, which is true, but she doesn't just take it. It has to go through a process if a will is not in place or a trust is not in place. She's got to go and open up an estate for you. The laws of intestacy of that state would apply and it would go to her. She's the only living child. But sometimes she has to prove that she's the only living child. She has to get affidavits to say that someone's known her for X amount of years, knew her mother, knew that the mother didn't have any other children, etc., etc. And another reason is that there's reluctance to cause division within the family. I was asked this question when I did this seminar a couple times before. One of the persons asked, what advice would you give a mother who did not, or was pretty reluctant about putting her will together because she's got 2 adult children and she didn't want to hurt one's feelings over another. And I said that the mom I would advise her to really have that conversation. It may be difficult, but it's better that she have it now while she's alive versus the other alternative is that she passes away and that the children fight over, squabble over the inheritance and become, arch enemies and the relationships are destroyed. You've got nieces and nephews and just people that never, ever would think about getting together again because of what someone didn't take time or didn't think about it. I don't think anything's done intentionally when it comes to the parents and their reasons, all these reasons I'm mentioning not to do it. I think they just think it's not necessary and have not thought about the consequences of not putting something together. I'll see it that way. And the last reason is that some people think, African Americans think, it's only for the wealthy. And we kind of mentioned that a little earlier at the introduction. But it's not. It is definitely for anyone that has any assets to decide how you want those assets to go. And one of the last things I have on here, next to the last, is that I talk a little bit about Aretha Franklin estate. Some of you may have heard about it, that there was a battle over her estate. Out of 4 children, I think 2 was on one side, 2 was on the other. And let's see if I have the facts here. Aretha died in 2018. And in 2019, I think her niece found 3 handwritten pieces of paper kind of with her wishes on it regarding her will. that was dated back in 2014. Well, two sets of children said, we want to go with our mom's will that was dated in 2010, which was put together by an attorney. And the other two said, well, it looks like mom had handwritten a will making changes, a 2014 will. So that was the basis for the lawsuit. In a judge ruled that the handwritten will from 2014 would suffice as being her will. I did see a little bit of it, and it was written as if Aretha was looking at the 2010 will and copying it. She starts off, it's my last will and testament, just like you would with an ordinary will. So it had a lot of credibility. In a handwritten will, the legal term is that you have a holographic will. That's a handwritten will. But the point I want to make, the reason it is inserted in this presentation right now, is that the kids were, it disrupted the family relationships between the two sets of children. The wills were, I think one of the wills, Aretha wanted the children to go to college. Another will, she didn't mention anything about college, so that was a major contention. It didn't have anything necessarily about the kids inheriting anything. They all were going to split her estate, I believe, 4 ways. But that was the major bone of contention, and it did break relationships. And I hope that they have mended it, but it did. You had one side against another, and no parent. We were younger, the parents didn't want us to fight, and certainly they don't want us to fight as adults. But let's move our attention to what a trust is. And I hope I'm not going too fast, just trying to get through this. What is a trust? A trust is a legal entity. And so what happens with the trust is that you put your assets into the trust during your life, and they're distributed at your death. Most times, just say a husband and wife, Michelle and Barack Obama, living trust. And so they are the trustees or grantors. They initiate the trust, and they are trustees. They manage it, and they're the beneficiaries initially. And then the children are the second beneficiaries if either one of the initial grantors pass away. And so one of the benefits of having a trust is that it's protection for your assets. It ensure assets are distributed according to your wishes. And the big thing is that it avoids probate. And that's probably one of the main things when it comes to why someone would choose to have a trust, is that it avoids the probate process. Even though with a will, the probate process is significantly shortened versus if you don't have a will. But if you have a trust, you just avoid probate altogether. So the living trust, that's one kind of trust. And the other is the living, revocable trust. And the other is a irrevocable trust. So if you have a piece of property, you live at 2225, Amherst Drive. In order to have a trust set up, we would have to transfer that property and retitle it the Michelle and Barack Obama living revocable trust. And that would be the title on the deed instead of Michelle and Barack Obama, just themselves on the deed. We would title it in the name of the living trust, Michelle and Barack Obama living trust. That's the name on the deed. So the deed kind of the trust houses your property. So all of your assets that you have, and usually the home is the largest asset that you're putting in the trust. But certainly all of your bank accounts can be retitled. All of your investments would be retitled and would be in the trust. The good thing about a revocable living trust is that you can move property in and out in your lifetime. You can sell it. You can manage it. You can give it away. You can do whatever you want to do with it. But once you pass away, it becomes irrevocable, meaning no changes can be made. Or on the other hand, you can have a irrevocable trust. You set it up. Once you set it up, it's pretty much set in stone and no changes are made. Let's see here. So I did mention in the next slide was going to go common types of trust. There's one more trust that I didn't mention. It's called a testamentary trust. It's created when you have a will, and the trust does not exist during your life. The trust becomes a trust once you pass away. And this particular trust does not avoid probate, because you have to, in a sense, it doesn't provide probate because the will has to go through probate in order for the trust to be created. This is a type of trust that may be appealing to people that have younger children. maybe they've named a guardian in the will, and then part of the will, in terms of the child being cared for, they create a trust for that child. Maybe it's a disabled child. So it can be created through your will, or can be created through a revocable living trust. You can also create a trust, a revocable living trust, and make provisions for a child with a disability as well. All right, I'll just touch a little bit about guardian and conservatorship. It isn't necessarily a topic that I was going to cover here, but I think it's worth mentioning. If someone's a guardian for a person, that's a court appointment. So maybe you are the conservator, or you are the, maybe you have power of attorney over the person, but the person is very much incapacitated, that now we need to approach the courts to get a legal appointment to become that person's guardian. And I said that because some nursing homes will not honor just a power of attorney. They usually always want you to have a guardianship and or conservatorship, become conservator over the person. And so if the person gets so incapacitated that you need to look at some long-term care skilled nursing facility, then you will want to consider becoming that person's guardian and conservator over their finances. So a guardian makes decisions over the person's physical care, and the conservator manages any monies that the person may have and makes financial decisions. In order to go to court to get a determination to become a person's guardian, it usually involves a physician's evaluation of the person's health. And that's not a hard thing to get. You would just accompany the person to the doctor and let the doctor know they're very familiar with this type of request and getting that to you in a timely fashion. But having a court appointment means that you are part of the legal system, judicial system at that point. So with the guardianship and the conservatorship, you have to make annual reports on how you're taking care of the ward, which is the person that you're taking care of under guardianship, and how you're managing the ward's money on the conservatorship. We're almost done. I'll be happy to take questions. Let's see. I want to continue a little bit on that long-term care. And I like to say, as we age, there's usually a certainty that we will need some sort of assistance, whether it's from a loved one, or we maybe need to live in an assisted living facility or a skilled nursing facility. And right now, the average cost of an assisted living facility is about $4,500 a month, or $48,000 a year. So even if we make provisions for our assets that we have, unless we're very, very wealthy, that money could be used up very quickly. So as an most common aspect of having some type of assistance, if we get to the point where loved ones can't care for us or desire not to care for us, is that we go into a nursing facility and we become Medicaid eligible. And I just want to mention that there's a 5-year look-back period regarding the real property. So if you own your home or you have certain assets, there's, I believe the threshold is about $2,000 per month that you can have, $2,000 and lower, that you're Medicaid eligible. And so anything higher than that, you wouldn't be able to get the Medicaid assistance to care for you or a person in a skilled nursing facility. And if you have any real property, so with a 5-year look back, what they do, Medicaid looks back and see whether or not you transferred any property within the last 5 years. And what they determine is that it looks like to them that the person is evading or trying to make sure that they're under the $2,000 threshold. So if my, well, I'm not giving legal advice, and I should have said that earlier. I meant to say that I am getting you information. So it's just something to consider, that if you are thinking about transferring property, and I like to say it at this point too, I've been asked often, a person has property, and say, whether do you think it's a good idea if I add my daughter on? And so my next question is, how old is your daughter? Okay, is your daughter married? Is she single? Does she have children, etc.? And so one of the considerations is, because some of you may be thinking, well, I'm going to make my property, I'll make my daughter or son joint owner with me on the property. And that way you certainly would evade the Medicaid eligibility, because Medicaid can't take property that you don't own outright. They won't take joint property. But some considerations is that if that person that you're jointly with, your child, your grandchild, etc., if at any time they become involved in any type of financial hardship with creditors, and then creditors want to file suit against them to collect on any debt that they have, or they're in a car accident, just saying that the scenario I give, that maybe they're not injured and maybe they don't injure anyone else, but the other person's car or property is destroyed, and maybe you live in a state. Here in Michigan, we have no fault, which is really great. So we don't get into a lot of disputes when it comes to automobile accidents. My insurance take care of mine, and theirs take care of theirs. But if you're in like a southern state, I visited my parents. It is a very litigious community. There's always lawsuits when it comes to accidents, even fender benders. So if you add someone onto your property, whether it's your children or any relative, you have to consider that it's a possibility that their financial liabilities may become your own, and may become your own to the extent that your property will be involved. Just something to consider. It is a way joint property won't be part of your probate if things went to probate. Even if you didn't have a will, joint property won't be part of that. Any property that you have named a beneficiary in terms of your retirement won't be part of that, won't become part of any probatable property. And let's see here. So some of the key takeaways, benefits of having an estate plan is that you give you and your loved ones peace of mind. You can direct the distribution of your assets. Your affairs will be managed by trusted designees. So if you have a will, you are directing how your assets will be distributed. If you have a power of attorney or power of attorneys, you directed your affairs will be managed by a trusted designee, and you decide your end of life care. And if you have a trust, it does avoid probate. And I need to say one thing about trust. Trust, they will avoid probate, but they will not protect you against creditors. That hasn't been a belief out there that many people think, if I get a trust, I don't have to go to probate and the creditors won't be able to touch my assets. That is not true. And one of the main reasons is that if you have a revocable living trust, the one I mentioned, that you can manage it yourself and go in and out, sell, because that means the property is available. If it's available for your use, then it's certainly available for your creditors. It is still part of your estate, assets that you own and have control over. If you have an irrevocable trust, the one I mentioned before as well, that irrevocable trust does protect your assets from creditors, but it kind of locks you out as well. You won't be able to do anything else with those assets. And so the wealthy do that if they have certain assets that they know they're not gonna, probably use for their lifetime. It's going to be just for their beneficiaries. Then they lock in those assets with an irrevocable trust. And another benefit is that you leave a legacy of good stewardship. You create generational wealth. So a legacy of good stewardship, we kind of setting things in place, for our kids to build upon. They see that mom and dad, what they've done. I just like to mention my grandmother. My grandmother couldn't read or write, at least that's what they say. But if you got in the car with her, she went places and she could tell you where to go and name names. And I think she picked up, the honesty, things along the way in her life. But my grandmother owned several pieces of property. She had her funeral expenses paid. She left money for us when she passed away. So she left a legacy of good stewardship, and she was saved all my life. So I just said that to say that we now have an opportunity to leave a legacy of good stewardship as well to our children. And we're on our way to creating generational wealth. And the last slide just says that stewardship is about recognizing blessings and managing them well. And the scripture is Psalms 145:4. One generation shall praise thy works to another and shall declare thy mighty acts. Okay. And thank you so much. If you have any questions, we can entertain questions at this time. Thank you, Evangelist Robinson, and to the listening audience, thank you.
Thank you so very, very much. You were so thorough, and it was so enlightening. Even a few things that I kind of had mixed up in terms of my thinking, but thank you so very much. I just wish that we were able to work out our technical difficulties, and I take responsibility for that. Um, and my apologies again. There were no questions. And I was monitoring the question I put out there. Feel free to ask questions if anyone has questions. Your information is available and on the screen. And so, of course, people know how to reach out to me. I kind of want you to go back over or clarify, um, is the durable power of attorney for health only, basically, and the power of attorney for financial and business uh, while the person is living. Did I hear that right?
Okay,
So the
that's a very good question. Yeah, and thank you. I know I was probably going pretty fast to
oh no, no,
get through this, but so we got our will. That's when the person expires. So what happens when we need assistance while we're living? And so we can get a power of attorney. One is for taking care of our business needs. That would be if we had any real estate we needed to sell, going to the bank for us, and investments, going to Secretary of State, getting our license or renewing our tags, anything business related. Maybe we manage properties and we need help to go over and collect money from our renters or take care of rental property we may have. That's the power of attorney. And usually
okay,
it's just called a power of attorney. I just want you to kind of keep that in mind. The ones we put together is we put durable on it because um, if you become incapacitated, the person can still take care of the business for you. Just
okay,
okay. So it's durable, meaning
okay,
it kind of it's good where you have your while you're not incapacitated. But if you were to become incapacitated, as long as you're living, we can take care. So just say if you were taking care from your aunt, and then your aunt started to get Alzheimer's, and so that power of attorney is still good. You can still use it to take care of business for her because you are her fiduciary and you're taking care of things the way you think she would really want them, even though at some point she may not be able to direct you specifically
okay.
how to take care of it. So it's durable power
Ex-
attorney. The other
okay,
is power attorney for the healthcare or hospitals may say, do you have your living will? Meaning that you prescribe how you want things to be done, your medical care at the end of life. And that also gives that person access to your medical records if need be, to speak to the physicians on your behalf if you're incapacitated and can't talk, can't make decisions on your own, then you've nominated a person to do that. And it could be most of my power attorneys, and most of them for any lawyer, I won't just say myself. We usually list a first alternate and maybe even a second. So there's maybe the husband would take care of business for the wife and would make health decisions for her. And maybe she named two other adult children just in case the husband isn't there. And maybe the husband expire and so it's no need to really get these documents redone again, because if the husband isn't there, the way it reads, if he's not able to or incapacitated, then the daughter does it, or maybe the son does it, whoever you designate as the second and third person.
so
So,
with wills and with trust, you can have in place the power of attorney and durable power of attorney. So
oh,
it's not
absolutely.
just for trust.
No,
So,
absolutely. You would,
okay,
if you're planning your estate, you want to definitely have a will and you want to have those two power attorney documents. Now, if you
okay,
want to consider the other thing, you can still have a will, the power attorney, the other power attorney for your living for your health care. And then you might want to have a trust. And the reason I keep the will on, even though you're getting a trust, is because um, the will is kind of a catch-all. With my mom, even, and my mom recently passed, but um, she found that she inherited some property. So if she didn't have the will and we just had the trust, then now we got to open up. We got to go to probate in order to get that the inheritance that she got, and in order to distribute it according to the laws of the state of Alabama. But if you have a will, the will says anything that you get goes into that person's estate, any money that they have at that particular time. So a will is necessary. I would recommend having the will as well as a trust, because the will is kind of a catch-all. Even if you.
So, how was she made? How did you all find, or did she know that she had an inheritance?
They,
Um,
they contacted her. The family member
okay.
contacted us. Yeah, and that's usually how it happens. That someone's contacting and saying this person died, and my grandmother. As I said, my mom was the only child, so my grandmother was no longer able to
Okay.
inherit that. Then it goes on to her child. Yeah.
Okay. Gotcha. Okay. Well,
Mhm.
this has been excellent, just excellent. And I'm so appreciative. I'm just, of course, offering my condolence to you.
Oh,
And, sorry that you were not available in the month, that it was out of your control for the
mhm.
month of March. But certainly, we will definitely have to have you come back and be with us. And so, what I'm going to do is go ahead and end the podcast, the broadcast, and have you remain with me just for a few minutes.
Oh, okay. Yeah, thank you. And thank you
Yeah.
so much for having me. It's been a pleasure. And hopefully
Thank
I've
you.
said something to
Oh,
benefit the audience and to make them want to take steps. The other thing I want to mention before we leave, real
yeah,
quick,
sure.
once you get your documents together, you want to put them in a place in a binder. So usually when I put these documents together for my clients, I give them a binder so that they can store it somewhere and let their family know. And with your power of attorney documents, you don't have to give them to your children. Just let your children know that where they are, just in case they need to get their hands on it. It's not anything for them to have. It's just for you, and it's just for them to know where these documents are when the time comes that they need to use them.
Gwen, clarify again if there is someone that has, you said uh, an only, only child, or what was that going to? When you mentioned that they die without a will
Okay.
or a trust,
Okay.
and so what typically happens, or they say, well, you know what, we don't need to contact the court, or if there's, I mean, I know of people who said, I don't have much inheritance and I don't need to do a will. I don't need, they're going to figure it out. How do
Mhm.
you respond to individuals that have that kind of mindset?
Mhm. Um, let's give an example. We said that the person may be an only child, and the I can think of my own family. My aunt, she had one son, and just say if she passed away, and the child stays in the home. He was living with her, caring for her. She's getting older, and no will is in place. And
Mm,
it looks like there isn't a need for a will. He's going to get everything anyway, but he doesn't have authority to sell that property. He doesn't have
yes.
authority to mortgage it.
Yes.
Or, sometimes people want to take some out to make some repairs or however they manage their finances. But so he would have to go to probate and open up an estate.
Right.
And like I said, a death certificate, birth certificate, and then they want to know, does she have any other children? So we need to get some affidavits, like I said, to say someone's known her. This is the only child she's had. And you need it kind of, maybe 20, 30 years, maybe not 30, but maybe 20 years. Someone's known you that long that they can attest to that this is the only child she's ever had. And so it is a process that even though you may have only one child, one heir, so to speak, you do need to have a will, especially if you own any real property or any substantial, even personal property that isn't jointly owned. You just have it in your name in the bank. And like you said, you figure only have one child, he's going to get it anyway. But a death certificate won't suffice. You won't be able just to take the death certificate to the bank. They would tell you you need a need to be appointed by the court as the executor over that person's estate. So there is a process that is involved if you don't have a will. And like I said, if you do have a will, especially, let me say one more thing, and I know we're probably getting over the time.
Oh, no, this is fine.
If you have a small estate in Michigan, if you have a small estate, meaning that maybe it's just a bank account the person doesn't own, maybe just say the persons are renting. It's a son and mother. They're renting. The mother's getting up in age. The mother eventually passes away. So they're living in a rental property. So all they have is a bank account, but maybe it's something substantial in the bank account. As long as it's under $28,000, that's considered a small estate. And what that person will be just appointed by the court. Sometimes that appointment here in Michigan can be done in one day. And you get that appointment and you take that to the bank and they're able to release the funds to you. Take it to the Secretary of State. They're able to retitle the car in your name. And you can use it for any other financial concerns that the mom may have had. So that's called a small estate. It's more direct, and it's for not to make it so cumbersome for people who don't own real estate. But even if you have the $28,000 or $27,000 in the bank, and then you have a piece of real property, it's not considered small, and it has to go through a little bit more formal process, but not as long as if you didn't have any will at all. So.
But if the person did not have a will, but their name was on the bank account, then would that suffice if they passed on?
Yeah, definitely. Any bank accounts that are joint, that is one way to manage the estate. So that one way to avoid probate is to have all of your, assets, your property, even jointly owned, and your bank accounts jointly owned. But like I said, before the consideration is that since they are jointly owned, everything in there is as much that person's money as it is yours, even though it might only be yours. It is as much as the person's property too, in terms of any liabilities that they may have.
Okay.
Creditors can attach it, lawsuits can attach it. So that's some consideration. You can't foretell the future, but just I just like for people to know the consequences, how things might go. But it's not a bad way. A lot of people do. They come and say, "Well, I don't need that because I got, he's on everything. My son's on everything, and on all my bank accounts, and on I've added him onto my home." So that there is one way to avoid probate.
Can you briefly? It's coming back to my mind again. You talked about a scenario where the actual court decides on the amount of the estate. You talked about maybe the estate was worth $300 and how they disperse that. Can you quickly just share how that happened?
It was an instance of I get kind of two scenarios. Just say the estate is valued at $300,000 and the husband dies without a will.
Okay.
Then we have to go to court and open up an estate, but we don't have any direction from him because he didn't have a will how he wants the $300,000 to be distributed. So we look in the law books, we look to the statutes, and Michigan says that the wife is entitled to the first $150,000, which will leave $150,000 left for she and the children. She gets one half of what's left. So she gets the first 150 and she gets one half of what's left. So she gets another 75,000, and the kids, whether it's 2 or 10, divide the remaining 75,000. That may not be bad, for if the children are products of the marriage. Most spouses would want their spouses to be taken care of, first.
And so that's even if they're adult children?
Even if they're adult children, even if they're adult children, it doesn't make a distinction for minor children. But the it becomes maybe an issue if this is a second marriage for him and all the kids are his and not hers. And so he passes away. She gets the first 150. She gets one half of the second 150, 75,000, and only 75,000 is left for his kids. And that may not be the way he would have wanted it. He may have wanted, maybe she gets 150, maybe the kids get 150. You know, maybe she gets 100 and the kids get 200,000 to divide among themselves. And
but
so,
if he has property and their names or they're the beneficiary, that would change things?
that would change that property. Doesn't go to probate. Exactly.
Okay.
So that is one way if he's had if he has some property and have their names on the property, or if he has them on some bank accounts, if they're joint, or if he has named beneficiaries for those accounts, that is one way. But like I said, if they're joint, you have to consider the potential liability by having anyone on a bank account, anyone on your bank account. I shouldn't say just children, anyone, adult children, anyone.
Well, I want to thank you once again. And I was just checking to make sure that whether or not there was any questions. And I'm appreciative of the comments that was made. Thank you, Gloria. Good information, as well as my companion. You really did. He said, this is a very good information and well delivered. Thank you. There is a question. Is your personal home protected in nursing home care?
I'm not quite sure what the question is asking, but let's just see. This is what I think the person is asking, whether or not your property will be considered as an asset that Medicaid can maybe, I know if a person is on Medicaid and they have some property, when they pass away, Medicaid tries to recoup some of that. So now I think the question is asking me, what happens if you're in a nursing facility? And that's that kind of eligibility that I was, let me see if I can, you guys can see the screen, I'm sorry. But let me go over it again, is that right now there's a $2,000 threshold. So your whole house income has to be $2,000 or less for Medicaid to pay for your nursing care if you need to be in a skilled nursing facility. If you're over that, and you wouldn't most likely be over if you own any real property. So the person would not be eligible for Medicaid to pay for their nursing home care. Some people try to get ahead of it and maybe transfer the property to someone else prior to 5 years. It's kind of hard to predict when you really might need nursing care.
Right.
Yeah, it's kind of hard to predict. And so Medicaid looks back. That's a look back. They look back 5 years and see whether or not the person transferred their real property. And if they did, the presumption is that the person did it in an attempt to make sure they would be qualified, would meet that $2,000 threshold. So any property transfer within 5 years of a person entering a skilled nursing facility kind of excludes them from having Medicaid pay for their nursing care. So your real property will be considered as part of your property. Now, the Medicaid statute names some other things, some other ways, and I'm not necessarily quite as versed, and I don't know whether those would be things that you would be able to consider. But from what I understand, that if there's a disabled child in the home, they won't take your property, or any minors in the home, or if the spouse is living and that's his only place that he, resident, they certainly won't take it and put him on the street or anything like that. So that would be reasons for Medicaid not taking the property or considering the property. But if it's a person, maybe the last spouse living, in the home, then that property will be considered.
Wow. Okay. Well, I tell you, this has been very informative. And thank you for all of your time and your knowledge and just your willingness to share. I know that it will be helpful. Of course, I will do my due diligence to send it back out and to indicate the value of this information, and it'll be there. And so thank you. Let me go ahead and end it, and please stay
Okay.
with us for a minute here.
Sure.